We will start with the updates, recent updates, and then subsequently go into questions and answers. Yeah, can you please help me turn it on? So, welcome. This podcast is every Wednesday, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. And of course, that is currently 1 p.m. Eastern Time. Um, I believe 11 a.m. Mountain Time and 10 a.m. Pacific Time. And currently, I think it's 6 p.m. Nigerian time. So you are welcome. Welcome, welcome, welcome. Today we have a lot to talk about, and as I was about to start this podcast, USCIS just posted a additional news on the Federal Register regarding citizenship questions, naturalization questions. So going forward, I'm still going to take my time to go over it, so I don't want to give wrong information because this was just posted about 5 minutes ago as I was just preparing to come on live. They posted it, so I'm still going to go over it and I'll be able to talk more about it. Please, can I have highlighter, please? Highlighter. At least the most important aspect is for me to determine the effective when these things are going to be effective, because I know that as we speak, a lot of people have citizenship application pending, naturalization application pending. So it is important to know when this new application, this new policy will come into effect. So very, very important. Thank you. Okay, I think I have that information. Maybe I should hold on. We go into the podcast, long into the podcast before I do this so that a lot of people will not miss that information. Okay. What do you think? Yeah. Okay. Do you have the cover? Oh, it's on the back. Oh, okay. Okay. Okay, so let's start. Today, talking about updates, the first update we'll be talking about is military lawyers that have been appointed by this administration to serve as immigration judges. Yes, this administration, they have approved the appointment of about 300 military lawyers who will be serving as temporary immigration judges. And they will serve for an initial period of 6 months, and it will be renewable for another 6 months. Of course, it's going to be a renewable term, so they may be there for years, but at least it's going to be on a 6-term renewable period. So military lawyers, lawyers who probably have zero experience about immigration law are now going to be acting as immigration judges. You can imagine. Immigration law is very, very complex, and I can tell you that I've been doing this for decades, and I see even immigration lawyers who have been doing it decades, they still struggle with some of these immigration complications. So how much more somebody who does not have any experience in immigration law now becoming immigration judges? It is really unfortunate, but that is where we are right now. So we just have to announce it. That is what is going on, and we need to announce it. That is military lawyers. Also, AILA, that is American Immigration Lawyers Association, they have announced that they have reported that there is an increase in NOID, notice of intent to deny, instead of request for evidence. By law, if there is an information that is unknown to an applicant or a petitioner, the USCIS is required to request for additional evidence or to bring it to the attention of the applicant or petitioner and give them an opportunity to respond before they can deny the case. But now, USCIS, under this new policy, they are trying to avoid requests for evidence and go straight to notice of intent to deny. Now, why is that an issue? Usually, a request for evidence will give an applicant or a petitioner up to 87 days, between 87 and 90 days, which is about 3 months, for them to be able to provide the requested evidence. On the other hand, notice of intent to deny will only give an applicant or a petitioner 30 days, statutory 30 days to respond. So if the documentation required is not something they can get within 30 days, then the case is going to be denied. So that is why that distinction is very, very important. But American Immigration Lawyers Association, they have reported that there is an increase in notice of intent to deny instead of a request for evidence. The next thing I want to talk about is that, well, for those who have been following our podcast, I talk about matter of AB and matter of LEA being reinstated. Those were the decision of the former Attorney General Session when he was Senator Session was the Attorney General of the United States. So he was the one that recalled these cases, these two cases from the Board of Immigration Appeal and issued a decision. And that decision has to do with people applying for asylum, especially as it affects asylum and refugee issues on the basis of family-related claim. So right now, this administration has reinstated those decisions. So if your asylum is based on family issue, either sexual molestation, either maybe your spousal abuse, all those things, you are probably not going to be eligible for asylum. Those things are going to be denied. Even though if you are able to bring them under PSG, particular social group, you may be approved under the previous administration. But under this administration, with the reinstatement of matter of AB and LEA, those things may no longer be eligible for asylum. So you will simply see more asylum cases being denied as a result of this new policy. Now, another update that I want to talk about before I go back to the issue of naturalization, because I believe that by now we are probably about 10 minutes into the podcast, so more people will have joined. So I'll go back to that. But before then, the latest update is that USCIS no longer allow non-profit organizations to provide voter registration and at naturalization ceremonies. For those who are naturalized citizens, you probably recall that usually wherever there are citizenship swearing in, naturalization oath ceremonies, you see different non-profit organizations, they will set up and be registering people on how to vote. They will be giving information on how to vote and all of those things. So going forward, USCIS is saying that non-profit organizations will no longer be allowed to register people or even participate in swearing in ceremonies. So they insisted that only state and local election officials will be able to do that. Okay, let me go back to the naturalization questions. Yes, as we were about to start this podcast, as I was preparing to go live, USCIS just posted on the Federal Register a new naturalization application, a new naturalization interview questions. Interview questions. They just posted it. In fact, it was posted around 11:55 Central Standard Time, and you know that this podcast starts at 12 noon, so it was about 5 minutes. So, and of course, I've not had time to read it because it's several pages. I have not had time to read the whole thing. I think it will be close to probably 15 pages and all of that. So what I just did was to print it because I don't want to wait till next week before I talk about it. And the only area that I'm going to talk about now, because as I said, I've not had time to read it myself, but I'm curious about the implementation. So I'm just going to read the implementation notice. So according to the notice that they posted in the Federal Register today, so okay, the new naturalization test will include 128 possible civic test questions, from which 20 test questions will be randomly selected for each individual test, along with answers to those questions. USCIS will also temporarily retain on its website the study materials for the 2008 naturalization civic test to help aliens applying for naturalization who will be administered the 2008 naturalization civic test. Okay, so for those under the current civic test for citizenship, they only ask maximum of 10 questions, out of which an applicant is required to pass 6 out of 10, even though you are given 100 questions to study. But usually officers will not ask more than 10, and you are only required to answer 6 correctly. But under this new policy, this new test questions, they are saying that it will now be 128 possible civic test questions, out of which 20, as opposed to 10, 20 will now be randomly selected. But the most important thing, I want to determine when it will be effective. Okay, according to the notice posted this morning in the Federal Register, aliens who have already filed naturalization application or who filed a naturalization application less than 30 days after this notice is published in the Federal Register will take the 2008 naturalization civic test. So what this means is that if you have a pending citizenship application or your application has been filed more than 30 days ago, you will still take the current questions, which is the 2008 civic questions. So if your application is already pending, you probably will take the old questions. But they are also saying that, oh, hold on. I hope I'm not reading it upside down. It says aliens who have already filed a naturalization application or who file a naturalization application less than 30 days, not more than 30 days, less than 30 days after this notice is published, we take the 2008 questions, less than 30 days. So the next one says aliens who filed a naturalization application 30 days or more after this notice is published in the Federal Register will take the 2025 naturalization civic test. How that doesn't make sense. So they are saying those who filed more than 30 days ago, they will take the new test. But those who just file less than 30 days, we take the old test. Does that make sense?
But didn't they just say that?
I mean, that's why I'm reading it out. I'm not paraphrasing. I'm just reading what is stated here. I'm not even paraphrasing. So let me read it again to be sure that I am not misleading people. I mean, I'm just reading it the way they wrote it in the Federal Register. Aliens who have already filed naturalization application or who filed a naturalization application less than 30 days ago or less than 30 days after, less than 30 days after, not before. The notice was posted today. Less than 30 days after this notice, we take the
Within the next month.
we take the old questions. Yeah, this thing doesn't make sense. So what they are saying is that if you file your naturalization application today or even in the next 29 days, you are still going to take the old questions. But if you now go to the second part, which says aliens who filed a naturalization application 30 days or more after this notice is published. Okay. Yeah, I think it's very clear now. That's the problem because I didn't have time to read and digest it before the podcast. Yeah, I think it's very clear now. So what they are saying is, if you file your application between now, because the notice was posted in the Federal Register today, this afternoon, if you file your application for citizenship between today and the next 29 days, you will still take the old questions. However, if you file your application 30 days from today, you are going to take the new questions. Okay, yes, that is very clear now. So for clarity, let me just go over it one more time. Aliens who have already filed a naturalization application or who file a naturalization application less than 30 days after this notice is published in the Federal Register will take the 2008 naturalization civic test. Meaning, if you have already filed your citizenship application or if you file it within the next 29 days, you will take the old questions. 2. Aliens who filed a naturalization application 30 days or more after this notice is published in the Federal Register will take the 2025 naturalization civic test. So, if you file your citizenship within the 30 days after today, you have to be prepared to take the new 2025 civic test. And then 3, with respect to aliens who qualify for special consideration because they are either age 65 or older and have resided in the U.S. as a lawful permanent resident for at least 20 years, USCIS will continue to administer a test with 10 questions from a specially selected bank of 20 test questions from either the 2008 or 2025 naturalization civic test. Specifically, aliens who have already filed a naturalization application or who file a naturalization application less than 30 days after this notice is published in the Federal Register will be administered a test with questions from the 2008 naturalization civic test, while aliens who file a naturalization application 30 days or more after this notice is published in the Federal Register will be administered a test with questions from the 2025 naturalization civic test. Regardless of either filing date, this alien will only need to answer 6 questions correctly to achieve a passing score. That is, those who are 65 years and old or older and they have been a permanent resident for 20 years. So they are saying that they will still allow them to either take the old question or selected question from the new naturalization application. Okay, like I said, it's a lot of pages. So if after the podcast, if I go over it, if there are new developments, I will talk about it next week by God's grace. But the most important thing is to let viewers know that today, about few minutes ago, they published in the Federal Register a new citizenship test questions, which of course is going to be effective immediately. But they are saying that those who have already filed their citizenship application or those who will file within the next 29 days, less than 30 days, they will still take the old question. But anyone who filed 30 days from now should be prepared to take the new questions. Because this was something that was posted about 5 minutes before we came on here, I've not even had time to check whether the new questions have actually been posted. But what I can say from the posting is that this is a combination of the 2020 question that was initially posted in 2020 and resigned by Biden administration. This is a combination of those questions and new ones that were introduced in 2025. So it is the combination of those two that produce the 120 questions that will be in the new citizenship test questions. Well, it's been 12:23 already. Let's go into questions and answers. Okay, you know what? Before I go into that, I also want to talk about EB4. I want to talk about EB4. That was what I actually planned to talk about this morning before this new citizenship question came up. I need to talk about EB4 because I get a lot of questions, especially from pastors and ministers who are waiting for visa bulletin. The visa bulletin for October 2025, which is the beginning of fiscal year 2026, has been posted. But I see that a lot of people, they misread the visa bulletin. Some people tell me that, oh, their visa is current right now. But when I looked at it, I realized that it was not current. So I wanted to talk about how to check whether it is current or not. In order to understand it, whenever we are talking about EB4, the first thing I want us to know is that there are several categories, there are several classes of applicants that were put together in EB4. I think I've mentioned this on previous podcast. EB4, I think they were granted about, 7.1% of the total allocation for employment-based visas. And when we calculated it, it was a figure slightly under 10,000. Now, the misconception is that a lot of religious workers thought that all these 9,000 plus visa allocations are for religious workers. No, they are not. And that is why I want to explain it today. Now, when we are talking about EB4, there are several categories of people that are clubbed together under EB4. And I've listed them out. One, we have religious workers under EB4. So whenever we are talking about EB4, religious workers are included. Whenever we are talking about EB4, we have SIJ, Special Immigrant Juvenile. Those who are in the United States and either they have been abandoned by their parents or either it is not in their best interest to go back to their parents, either because of abuse, abandonment, and all of that. A district court in the United States will have to make a determination that it is not going to be in the best interest of the child to be reunited with their parents, and they will either appoint a guardian for the child, or a U.S. citizen can volunteer to take charge of the child. So once such a court order is made, then that citizen can apply for legal status for that child. That is what is called SIJ, Special Immigrant Juvenile. So for all those SIJ petitions, they also come under EB4. The next one that come under EB4, they are US government employees abroad. Maybe you have worked with the US embassies all over the world. You have worked with them for not less than 10 years. And then maybe you resigned you resign or you retire. Not that you are fired. If you are fired, you will not be eligible. But if you retire or you resign and you want to live in the United States, you can actually apply for green card under EB4. These are still part of EB4. The next category of people under EB4 are broadcasters, foreign broadcasters. If you are a foreign broadcaster and you want to live in the United States, you want to apply for green card, you do so under EB4. That is still part of the EB4 category. Then the next one is for certain foreign nationals who served honorably in the U.S. Armed Forces. For example, maybe while the U.S. was in Iran, if there were Iranians who were fighting on behalf of the US government, if they subsequently want to live in the United States and they want to apply for green card, they will have to apply under EB4 category. Then also, I think I've mentioned 5 now. Also, if you are a retired employee of designated international organizations, not all organizations, but designated international organizations, example, United Nations or World Bank. So if you work for United Nations, maybe in management position, or maybe World Bank in management position, you know that those offices, they are located in the United States. United Nations headquarters is located in the United States. World Bank headquarters is located in the United States. So if you work for all these organizations and then you retire and you want to apply for green card, you apply under EB4. You are still under EB4. And of course, the same EB4 is reserved for certain physicians. If you are physicians licensed and practicing in the United States since before January 9, 1978, of course, it would be ridiculous for somebody to be licensed and be practicing in the US since 1978 and still don't have green card. But again, this is provision of the law. So if you are in that category and you now want to apply for green card, you need to apply under EB4. And finally, if you are Afghan and Iraqi nationals and you work with the US government, either the US government, the military, ISAF, or other supportive role, either as translators or something like that, and you want to live in the US, if you are going to apply for green card, you'll be applying under EB4. Now I've listed 1, 2, 3, 4, 5, 6, 7, 8. So those are 8 classes of people, 8 categories of people. So religious worker is just one out of 8 that have to share that figure of 9,000 plus. So because the US government is very aware, they don't want a situation where one category out of those 8 categories will use up majority of this visa availability. So they separate them individually. So whenever each class of people have finished their own allocation within the EB4, they usually put U, which means unavailable. So EB4 right now, for some of these categories, the visa bulletin may show a different date, but for religious workers specifically, it is still unavailable. For religious workers, it is still unavailable. How come this phone is ringing? It was put in silence. I don't know. Okay. So, whenever you are looking at the visa bulletin, look at the line under religious workers. And again, you also have to look at whether the applicant is here in the United States, in which case you look under final action. Or if the applicant is applying from outside the United States, then you look under visa applications. So I want to make that clear so that whenever you look at visa bulletin, you know exactly where you are on the list. Our time is fast spent. Let's go into questions right now. Is it the first question that says, in God we trust? Is that the first one?
It's not a question, but it's just
Oh, okay. Good day, sir. God bless you and your team highly. Thank you. Amen. So, what's his first question? Okay. Good day, sir. I'm on H-1B in the US and engaged to someone in the UK. He just got a US visitor visa. Can he enter? We marry here, then return to the UK for H4? Oh, yes. Oh, yes. But the only thing is, this person didn't say whether this person in the UK is using UK passport or is just residing in the UK. Why is that important? It is important because if the person entered the US with a visa, she can actually apply for a change of status from B1, B2 to H4, even in the US. However, if the person entered the US with a visa waiver, then he will have to go back to the UK and apply for H4 visa. But then, to be able to do that, you will need to first file I-824, application for action on an approved petition, so that the USCIS will forward your file and your H-1B approval to the US Embassy in the UK before she can apply for H-4 visa in the UK. Next question.
I don't know if that's a question.
It's not a question. It's just a good afternoon, sir.
Oh, okay.
Oh, the first one too is just a greeting.
Oh, it is.
Yeah, Eku Ọjọ́ Mẹ́ta is a greeting in Yoruba.
This
Okay.
one is a continuation from the one you just answered.
Okay. In addition, I'm in the process of filing an EB1 petition soon. Will you advise submitting EB1 now, pause on adjustment until after marriage if marrying in the US on a visitor visa is not advisable? Well, again, I already answered that question. I don't know if this person is coming in with a British visa or is just resident in the UK. I will be coming with a visa that does not require visa waiver. If it's a British visa or a visa waiver country, they cannot change status in the UK. In the US, they will have to go back to the UK. But if this person is coming in with a visa, he may be able to apply for H4, change of status in the US, and then if you apply for EB1, both of you can apply together for the adjustment application. But if this person is not able to apply for a change of status in the US, then if you apply for EB1, you can either file it on your own for as long as the marriage occur before your application for adjustment, she will still be included. But if the marriage occurred after, then you may need to get your own green card and then petition for your spouse. Next question. Hello, Dr. Asekun. Just filed VAWA, but also have a pending asylum, which was filed after 1 year. I like to withdraw the asylum case and stick to VAWA. What do you advise? Well, I don't know if this person has received the receipt notice for the VAWA. If you have received the receipt notice, I will advise you that you send a letter to the asylum office telling them that you intend to withdraw your asylum application, and then also notify them that you have a pending VAWA application. Why is that receipt notice important? It is important because without it, even if you withdraw your asylum, they will still place you in removal proceedings. So to avoid removal proceedings, it is important that you attach evidence of your pending VAWA along with your withdrawal application. Next question. Hello, sir. Once the NVC application is documentation complete, when will the case be sent to the Lagos consulate? It was documentation complete as of July 17th. Unfortunately, this is one of those questions that I don't have an answer to. The NVC have been very, very inconsistent in the last 5 years. In fact, since COVID, they have been extremely inconsistent. We have seen cases that were expeditedly, even without requesting for expedited service, that were expeditedly sent to the embassy and an appointment was scheduled. But we also have cases, even in this office, that have been documentarily complete since 2023, and the NVC, the embassy have not set interview date. In fact, as I speak with you, I have a lawsuit pending against the U.S. Department of State over this particular issue. We have cases that have been pending and the embassies are not scheduling appointment for reasons best known to them. I mean, this is in relation to the U.S. Embassy in Nigeria. So we have 2023 cases that have been documentarily complete since 2023, and up till now, no interview has been scheduled. So I have to file a lawsuit against the Department of State. The lawsuit is still pending. So this is one area that I cannot really tell you how long it will take, because they are cherry picking which cases to be scheduled for appointment and which one not to be scheduled. And I really don't know what criteria they are using. I mean, we've have cases in the same category. Some of them were scheduled, some of them were not scheduled. So we really don't know what criteria they are using. And that is, again, one of the reasons why we went to court. So the case is still pending. Once we have a decision, I will update this. I will update my listeners on the outcome of the case. The next question. As a green card holder, I will be eligible to file for citizenship by March next year. My mother arrived on June 1st, and I plan to file for her based on my green card. Can she remain in the US while I submit her application? I'm concerned that if she leaves the US now, the processing time will be longer. What do you think I should do? Thank you. Well, very good question. First and foremost, as a permanent resident, you cannot petition for your mother. I've said it over and over and over on this podcast that the way the US law interpret, or what the US immigration law consider a family, is different from what the English dictionary considered a family. One of the major differences between a US citizen and a permanent resident is that for permanent residents, parents are not categorized as immediate family. For US citizens, parents are categorized as immediate family. In other words, only a US citizen can petition for parents. Permanent residents cannot petition for parents. So if you are going to petition for your mother, you can only do it after you become a US citizen. You cannot do it as a permanent resident. However, if you are going to, if you desire to keep your mom here before you become a citizen, that is possible. Just make sure that you apply for extension of her status before the expiration of her current status. I'm assuming, although I don't know for sure, but I'm assuming that they probably gave her 6 months. If that is the case, did she mention when she arrived? Okay, she arrived on June 1st. Okay, so if they gave her 6 months, that will probably be expiring by December 1st. July, August, September, October, November, December. Yeah, that should be expiring by December 4. So anytime from maybe October, November, you can file an application for extension of our B1, B2 and request for 6 months. Of course, you have to provide an explanation why you will need an extension. But you apply for extension, 6 month extension for her. If that is approved, that will take her till June of 2026. So if you apply for citizenship by March of next year, even if your application is not approved before June, all you need to do is to submit a second application for extension of status for her by before June 1st of next year. Even if that application is not approved, for as long as you submitted it, that will buy her some time. And then once you become a citizen, the same day you become a citizen, you can submit a petition for your mom. That is the only way you can, or the only thing you can do. You cannot petition for her as a permanent resident. Next question. Hello, doctor. My friend got an RFE for I-485 that says his co-sponsor didn't qualify for 864, but the person is earning 90K annually and only 2 households. What can we do, and your take on this? Again, this is a question that I believe that I've answered on this podcast multiple times. It is not the amount of income that determines whether somebody can sponsor or not. Somebody can be making 6 figures and not be able to, not qualify to sponsor, whereas another person can be making 40,000 and be qualified. They are not looking at the total income. What they are looking at from the tax return is what is called adjusted gross income. Adjusted gross income, AGI. That is what they are looking at. So if you go back and look at the tax return of this person that is earning 90K, you will see what the figure is. So adjusted gross income is what they look at. Somebody making 40,000 may be able to sponsor you, whereas somebody making 120,000 may not be able to sponsor you. So it is not the amount of income, it is the adjusted gross income. So if you go back and look at the adjusted gross income for this person, you will see that it is probably a very small amount. And of course, what can you do? You have to look for another joint sponsor. If this person's income is not sufficient, you have to look at a joint sponsor. Or if this person can show asset, then they may also consider asset. But rather than go through the hassle of providing asset and all of that, just look for another person to co-sponsor. But what you are looking at is not the total income. When you look at your tax return from 1040, earning the wages, the total wages, that is not what they are looking at. You look under it, still on that page 1, first page of from 1040, look at AGI, adjusted gross income. It is the amount under that, in that line. That is what determines whether somebody can sponsor you or not. Next question, please. Okay, from the 20 questions, what will be the pass mark? Again, as I said, I've not really had time to digest this information. It was something that was posted on the Federal Register few minutes into this podcast. So I just printed it out In fact, it was during this podcast that I was just looking at what the effective date was. That was the only thing I've looked at so far. So I've not had time to digest it, but I'm assuming that they probably will want you to maybe 10 to 12 questions, because when it was only 10 questions, the pass mark was 6. But now that it's going to be 20 questions, I'm assuming that the pass mark will be higher. But again, I don't want to give out information that I'm not sure about. I've not had time to digest it. So I will do that, and if by next week, by God's grace, there are additional information, I will post it.
We could post a reel about it.
What?
We could post a reel, like a short about it.
Oh, okay. Yeah, if we have the information, we will also post a reel on our social media platform. Okay, next question. Good day, sir. I got IA24 follow to join for my wife. Approved. EB2. The letter said the approval has been sent to consulate. Is this right? I was expecting NVC. The beneficiary wife name was not mentioned on the approval notice. Yes, it is normal. When I was answering the previous question, I did say that NVC is very inconsistent, and to be to be honest with you, they are becoming extremely difficult to predict. So we have seen IA24 sent directly to the embassy instead of NVC, and we have also seen initially, the first time I saw it, I thought they made a mistake. It was supposed to be sent directly to the NVC, but they sent it directly to the embassy. But I encourage my client to attend the interview at the embassy, because the embassy scheduled my client for interview, and my client attended the interview, and of course, the embassy attended to my client. So it is not a mistake. It is something that they do nowadays. I don't know why, but I mean, things happen. I've seen cases like that where they sent it directly to the embassy instead of NVC. So just tell your wife to be prepared. So if you have not already submitted the immigrant application, just quickly do it and wait for instruction from the embassy. So once they send you an email, read the email and just follow all the instruction in it. But it's not a mistake. It's something that they do once in a while. Okay, next question.
Oh, and then he asked about the wife's name not being on the approval notice.
No, it doesn't matter. It doesn't matter. Once the IA24 has been sent to the embassy, it should just follow the instruction on the email received.
And then this was the last one. But
How will I know they have sent the approval to the NVC? They may not send it to the NVC, like I said. So just follow through with the embassy. They may not send it to the NVC. Like I said, we have seen cases like that before. Next question. Does the new 3-month maximum duration visa policy for non-immigrant visa affect applicants who are getting work visas like O1 and H1B from the embassies overseas? No, that one is only for visiting visa, B1, B2. It doesn't affect those ones, because those ones are employment-related visas. O1, H1B, R1, all those ones are not affected. It is only visitors for business or visitors for pleasure, B1, B2, that are affected. Next question.
this is the second part.
Okay. God bless Dr. Olu. Amen. Thank you. Do non-immigrant visa categories like O1 and H1B still get temporary reside in the USA for work, or will they be subject to the maximum duration of 3 months? Oh, it's the same question asked in a different way. No, they are not affected. Those ones are employment visa. They are still valid for, I think O1 is 1 year and H1B is 3 years. They are still valid. They are not affected by the 3 month, 90-day period. Those are B1, B2 only. Next question, please.
This is similar.
Okay. Sir, I'm currently in US with B1 visa and applied to change status to L1. Please, what's the processing time for an L1 visa? Also, please, can you clarify L1, L2 visas are part of the 3-month validity period for Nigeria? No, I already answered that. They are not part of it. And as for processing time, it is not predictable. But what I can tell you is that I believe that L1 is eligible for premium processing. Can you please confirm that? It should be, but I'm not 100% certain. Can you please check? L1B, I-907, premium processing, to see if L1 is included. I think it is, but let me just confirm. Yeah, so regular processing is not predictable, but if premium processing is available, just apply for premium processing. You will get a decision within 30 days. Move to the next question while you are checking that, please. Good day, sir. Ekusho, thank you. Do I need to file removal of asylum application after my son has submitted I-130 since April 2025? Well, if you have a pending asylum application, well, this person didn't indicate whether the asylum is affirmative, pending with USCIS, or defensive, pending at the immigration court. If your asylum is still pending at USCIS office, all you need to do is to send in a letter of withdrawal of the asylum, send in the I-130 receipt notice and the I-485 adjustment application, and state that as your reason for withdrawing the asylum, that you now have a pending petition filed on your behalf by your U.S. citizen child, as well as a pending adjustment application, and as a result, you now wish to withdraw your asylum application. On the other hand, if your asylum application is pending at the court, EOIR, that is defensive asylum, USCIS will not have jurisdiction over your adjustment application. Therefore, you cannot withdraw the asylum application. You have to wait for the I-130 to be approved, and then you go to court to apply for adjustment of status in court. Next question, please.
Going back to this one, L1 is available for
Premium processing. Okay, yeah. Going back to the L1 question, premium processing is available for L1. So, like I said, you can apply for premium processing, that is expedited service. They will process it within 15 to 30 days, maximum 30 days, not less than. It may be less, but it cannot be more than 30 days. But you pay more for expedited processing. Next question. I've been scheduled for an interview next month without the approval of my EAD. Is this interview scheduling without EAD approval a bad sign? This person didn't say what the application type is. Is it family-based? Is it asylum? Anyway, it doesn't really matter. It's not a bad sign. The EAD is processed by a different department. It has nothing to do with the interview. I've seen cases where employment authorization was approved after interview. I've seen a situation where it was approved on the day of the interview. I've seen a situation where it was approved few days to interview. They are two separate departments. They are not the same department. Usually, interviews are conducted by local office, whereas employment authorizations are processed by service centers. So they are not the same thing. So it is not a bad sign. It has nothing to do with bad sign. Next question. Additionally, I overpaid for my I-765 by 520 instead of the required 260. What steps should I take to request a refund? Thank you. Usually, if the amount is not correct, USCIS will return your payment. They will not even take it. They are not going to take 260 from your 520. No, they are going to return it. So if the amount you sent is not the actual amount, you should be expecting your application to be rejected. They are going to send it back. You may still not have returned it, not because they have started processing it, but because they are going to send it with regular mail, which may take several weeks before you receive it. So the USCIS will not deduct 260 from your 520. No,
as long as the amount is more than what the amount that they're actually supposed to pay, sometimes they will just take the amount that you're supposed to
Okay,
pay.
I've just been told here that if you pay the filing fee with a credit card, you know that with credit card, they have not actually charged the amount. It is just an authorization for you to charge the amount. If you pay with a credit card, they can actually charge you 260 instead of the 520. So if you have received receipt notice, check your receipt notice and see the amount there. But if you pay with a check or any money order, cashier's check, and all of that, they are going to reject the application. They are not in the habit of deducting and subtracting. No, they don't do that. But if you pay with a credit card, they may just charge you 260 instead of charging you 520. Next question. Hello, sir. I filed my I-30 for my wife, and under my progress, I'm told 11 months until case decision. Is this accurate? Well, the word accurate, no, nothing is accurate when you are dealing with USCIS. If you keep looking at it, you will see that sometimes that number will change. That 11 months can actually change to 20 months. It can also change to 10 months. Accurate, no, nothing with USCIS is accurate. But it just gives you an idea. That's it. It's not accurate. Yes?
We had a client who said it was going to be adjudicated within a week, and then a day later, it said 9 months.
Aha.
So
So yeah, anything with USCIS accuracy, no. They are not, that's not their language.
this is from earlier. They are just doing for clarity.
Okay. Thanks, sir. For clarity, the UK spouse is a resident work visa which will expire February. Is coming here on B1, B2. I'm just confused on if we get married being a visitor, it won't be refused H4 in UK. Well, if since he is coming in with a visa, if you get married here, you can actually apply for his H4 visa here. You can apply for a change of status from his B1, B2 to H4. But if you decide to apply in the UK, one thing you need to understand is that H1B and H4, both of them are still within the discretionary visa category. So they can still be denied with or without reason. So if you want to avoid that risk, when you are here, he can apply for a change of status from B1, B2 to H4 for as long as it is done before the expiration of the I-94. And of course, you show that this was a legitimate marriage. Next question. I'm a marriage green card holder since February this year. I have petitioned I-130 for my 2 kids in Nigeria in March. Will it more faster if I refer the I-130 using my wife as petitioner? Well, yes, but that depends on a number of factors. You see, some of these questions are not questions we can answer with a yes or no answer without additional fact. For example, how old are your children? If your children are 18 and above, your wife may not be able to petition for them. But if they are under 18, your wife may be able to petition for them. So it is in your best interest, if they are still minor, they are under 18, yes, to use your wife as the petitioner, because that will be faster. That will qualify under immediate family. So immediate family are processed more faster than a permanent resident petitioning for family member. For the purpose of being fast, yes, your wife being the petitioner may be faster. However, I also need to let you know that your wife being the petitioner may also come with its own challenges. I pray that your marriage works. But if for any reason, after the petition is filed, if you have any issue in your marriage, you know that is going to affect the petition, the ability of your children to come here. So sometimes it is in every case, you see, when it comes to immigration, every case is different. You know your situation better than I do. So if there is any issue in your marriage and your wife is the petitioner, it may affect everything. So what you are intending to achieve may turn out to be problematic. On the other hand, if your wife is the petitioner, if your children are under 18, that will be much faster.
Yeah, he said that they are under 18, and then he was asking how much faster, like how many months.
The issue is if your wife is the petitioner, there will be no issue of visa availability because immediate families don't wait for visa availability. So that issue will be eliminated. So as soon as the I-130 is approved and sent to the National Visa Center, you start the process right away. On the other hand, as a permanent resident, if the case is approved, if until visa becomes available, National Visa Center will not even allow you to submit any paperwork or even start the process. So it depends on a number of factors. So it's not something that I can tell you that, oh, it's going to be 6 months faster or 2 months faster or 1 year faster. No, it's not one of those things. But it depends entirely on visa availability issue. For immediate family of a U.S. citizen, they don't go through visa availability. Whereas for immediate family of permanent resident, they still have to ensure that visa is current before the National Visa Center can even allow you to make payment or even commence the process. Next question. I got a bona fide determination letter on U visa. Is it advisable to withdraw my asylum petition, which has been pending for years? Well, I will leave both pending. Because bona fide determination is not the same thing as approval. It is just like the case of VAWA. The fact that you get a prima facie determination letter for VAWA does not mean your VAWA is going to be approved. So I will leave both of them pending. That is what I will do if I'm in your shoes.
And U visa takes a very long time.
Yeah, U visa takes a long time. So I will just leave both of them pending. Next question, please. Hello again, sir. If the NVC has said document is complete for a family visa, will they be invited for interview at embassy? Oh yes, if they say that the case is documentarily complete, the next stage will be for you to receive interview appointment letter at the embassy. Usually the NVC get in touch with the embassy. It is the embassy that will provide interview available dates, and then the NVC is the one that will send you that interview appointment letter. Next question. Can someone with unmarried child pending application waiting for over 10 years get married before an interview? No. Well, I'm not going to say exactly no. This person didn't indicate who is the petitioner. If the petitioner is a U.S. citizen, there will be no issue. There will only be a change of category. But if the petitioner is a permanent resident, if the unmarried child gets married, that petition is terminated by operation of law. USCI does not need to do anything. It is automatic. The petition is terminated by operation of law. But if the petitioner is a U.S. citizen, the petition will change category from unmarried children of U.S. citizens to married children of U.S. citizens. It will change from F1 to F3. Okay, next question. Hello, doctor. Great job you are doing. Thank you. Do you think the EB4 will reach priority date of 2021 soon? I think they are actually in 2021. I think so. Also, are they using filing date to adjudicate for people in US now? Yes, for US, you look at filing date. For people outside, you look at visa application. For inside, you use final action. For outside, you use visa application. Yeah.
But
No, check I think for visa application, they are actually in 2021.
let me see.
Check religious workers,
Yeah.
EB4.
Certain
I believe they are
religious.
in 2021, the last time I checked,
The
which
final
was
action
probably
date
yesterday. No,
says
not final action. Final action will only show you.
yeah. It shows February 2021.
Aha, they are already in 2021.
Yeah.
They are in 2021. So
February. So
yeah, they are already in
still have time.
2021. So they will probably be reaching your turn soon.
Oh yeah.
But
Let me see. October was released. Hold on. October.
oh, you didn't check the October. Yeah, check the October. The October has already been
October.
released.
For
Because October bulletin is the start of the
yeah.
2026 fiscal year.
So for just EV4, it's July 2020. But for certain religious workers, it shows you.
That's for final action. Check
For
under visa
both,
availability.
for both
For visa,
religious workers, both of them, it's you.
even for visa application.
See, this is the dates for filing. Here, you can unplug it.
Yeah, for visa. Yeah, for religious worker, it's still you, but for
Just EV4.
EB for February 2021. Yeah.
Okay.
Okay, let's go back to the question.
Okay.
Okay,
Also, are they using?
do you think the EB4 will reach priority date of 2021 soon? Are they using filing date to adjudicate for people in the US now? Well, I remember, I don't know whether it was 2 weeks ago. I remember in one of the recent podcasts, I did mention something about DHS coming up with a policy that they will they will be using the same date for both final action and visa application. So that's why I've been checking the same date. And for both right now, for religious workers, they are both unavailable. So they are still not current. But when will they be current? That is not something that I can predict. But of course, we keep checking every month, month to month. As I stated at the beginning, there are 8 different categories of people that are competing for under EB4. So religious workers is just one of them. And a religious worker probably have the highest number of petitions. That is why they separate them. Because usually what they do is that anyone with unusually large number is treated separately. That's why they treat people, countries like Mexico, India, China, Philippines. That's why they treat them separately. That's why Nigeria is not allowed to play the visa lottery because they have exhausted their own numbers. So normally that's what they do. So right now it's unavailable. So it's not something that we can predict. I mean, we can get to next month and the thing may move. So we really don't know for now. Even USCIS themselves cannot predict it. This is something that only the Department of State handles. Next question. Good afternoon, sir. God bless you richly for all you do. Amen. Please, sir, what is the timeline of submission of document to the consulate? Getting a sponsor has been really tough. Well, I'm assuming that this person has gone through NVC stage because usually NVC stage, that is where documents are submitted, except like the cases of IA24 we have been talking about. If you receive direct communication from the embassy as opposed to NVC, as far as NVC is concerned, you have to contact them within 1 year. If you don't, the case can be terminated. So there is really no timeline, but you have to contact them within 1 year. So that is the rule. But as far as the embassy is concerned, if you get direct communication from the embassy, usually the embassy will give you a date for you to appear at the embassy, either for document review or for interview. So if it is for document review, you need to get all of your documents ready before the appointment date. And of course, if it is for interview, it is usually because they have reviewed your document. So if there's any additional document that you need, you have to get it ready before the interview date. Next question, please. How long are they taking to issue C9 EAD and advance parole for adjustment of status? Again, many of these things are not predictable. Many of these things are not predictable. I mean, USCIS is so inconsistent now that it's becoming almost impossible for us to predict any timeline. I mean, we have seen cases of C9 EAD that were issued within 2 months, and we have seen cases that were not issued in 10 months. So very unpredictable. They are very, very unpredictable. So it's really difficult. But if you go back to the service center that processes it, they will tell you, they will give you an average of 6 to 10 months. But again, sometimes we get it approved in 2 months, and sometimes you don't even get it approved in 10 months. But on the average, it's 6 to 10 months. Next question. Good afternoon, doctor. May God continue to bless and enrich you. Amen. What is your take on filing for N400 when your I-751 is still pending? The I-751 was submitted by both couples with a lot of evidence. Is there a second part or that's it? Okay. Yeah, it's a good thing. Once you are eligible for citizenship and your 751 is still pending, go ahead and apply. Most of the time, it forces them to expedite your 751. Go ahead and apply. But just make sure that your house is in order in view of all the recent policies on naturalization, including neighborhood investigation and all of that. But of course, if you're already eligible, go ahead and apply. It actually will make your I-751 to be expedited. We have seen several cases where both the 751 and the naturalization are adjudicated on the same day. So there's no problem in doing that. But as far as the citizenship is concerned, make sure that you put your house in order. Be prepared for neighborhood investigation. Next question, please. Good day, sir. I received request for FD 258 fingerprint for my beneficiary based in Nigeria. Please, where can this be done? I saw consulate in the letter. Someone told me it's Alagbon in Lagos. Well, if you are from Nigeria, I know that it is only Alagbon that does fingerprint for immigration purpose. It is only Alagbon in Lagos. Yes, that's the only place in Nigeria where it is done. But if this is a consular processing, you need to understand that if your wife has lived in any other country apart from Nigeria, she will have to provide fingerprint from every country that she has lived for at least 6 months since age 16 in order to avoid delay in the processing of your application. Next question. How faster will it be? About how many months advantage? Is it the same one about?
No, sorry, the one above. Good day, sir.
Oh, okay.
So what can I do to Mr.
Okay.
73?
Good day, sir. Please, what can I do to my son's I-130 case that was sent back by the embassy to USCIS without issuing a visa? Is the next one a continuation or a separate question? Okay. Yeah, usually if it's an immigrant visa, which is what I-130 is, the embassy will send it back to USCIS with a recommendation that the approved I-130 should be revoked. But by law, before USCIS can revoke it, they will contact you, the petitioner, and give you notice that they intend to revoke it. And they will now tell you what the embassy said and give you 30 days to respond, to tell your own part of the story. Tell them why the petition should not be revoked. So once you respond within the 30 days, USCIS will now decide whether to revoke it or not. Sometimes they will reaffirm it. They will send it back to the embassy, tell them that, well, we have gone through your concern and we stand by our approval. In which case, the embassy will ask you to come back or ask your child to come back for another interview and then issue the immigrant visa. On the other hand, if the after you respond to their notice, if USCIS side with the embassy and decided to revoke it, then you will have a right of appeal because I-130 petition is an immigrant petition, and as a US citizen, you will have a right of appeal. So that is the procedure. But is this a continuation? How faster will it be? About how
No,
many?
that's different. That's a different question.
Oh, okay.
Yeah, this is the next question.
Okay. Thank you for all you do and your team do. Thank you too. We appreciate it. My parents are currently green card holders since November 2024. They have both come into the US twice. They need to be in Nigeria longer than 1 year. Please advise. Very simple. Whenever they come to the US, or if they are currently in the US, they need to apply for advanced parole. Oh, no, not advanced, travel permit. They need to apply for travel permit. That travel permit, USCIS will give them a passport. That passport is issued by the United States Department of Homeland Security. So they will be able to stay out of the country for as long as they want without losing their green card, without any problem. The only challenge is that travel permit, they have to apply when they are physically present in the US. They cannot apply while they are outside the US. They have to apply when they are in the US. So if they are currently in the US, let them go ahead and apply. If they are outside the US, tell them to come back in. Once they come back in, they apply, then they can go back. They don't have to wait until they approve it. All they need to do is to apply while they are here in the US. That is the requirement of the law. They must be physically present in the US at the time of application. But once they apply for it, they get that passport, they can continue to use that passport along with their green card. And then they can stay out of the US even for up to 2 years without any problem. Next question. Please, sir, is it still okay to put in now the first renewal EAD of my teenage kids who are still under 18? Their first issued EAD card was issued 2021 and it expired in August 2023. What should I do? Well, this person didn't indicate what is pending.
Yeah, like what category?
What is pending? But generally, if you have a pending application, yes, it's always good to apply to renew their EAD because that is one thing they will be able to show if they have to either renew driver license or apply for driver license or even show evidence of legal status. That is one thing they will need to show. It doesn't matter whether they are under 18 or not. You know, in this country, children start driving from age 15. And it is not when they need to drive that you now start applying for EAD. It's better to do it now. The good thing is that EAD now, they give 5 years. So if you apply now, they have 5 years. That will take them to, depending on when it is approved, it takes them to either 2030 or 2031. That will even be, it will take them beyond this administration. So I will go ahead and apply. The next question, what advice will you give for an R1 visa holder whose visa expires in January 2026, but its priority date is December 2023?
Depends on how many years they've been on R1.
I'm assuming that this person is talking about the 5 years expiring 2026. If the last 5 year, that the last portion of the 5 years is the one expiring 2026, then you will have to apply for a change of status to keep yourself in status. But if you have a space in between, if you have any period that you spent outside the US, or any period that you didn't work for the employer, you can still reclaim those periods. For example, I once represented a client. I applied for R1. The R1, we put a start date, a particular start date. The R1 was denied. We filed an appeal. The appeal was denied. We went to court to challenge the denial. So all those things took about maybe about 1.5 years. Eventually, it was approved. So when they approved it, they backdated it to the initial date that we requested. So when it was 5 years, I applied to extend it to reclaim those 1.5 years that were not, because for those 1.5 years, he didn't have the opportunity to work for the employers. He was actually not on R1 because those were the period that we are going through the procedure. So we requested that immigration grant extension of that 1.5 years, which was done. But assuming that you don't have any time left, if the final 5 years is the one that is going to expire in 2026, in order to keep yourself in status until visa becomes available, I will advise you to find a way to change your status and keep yourself in status, since you already have an approved 360. I'm assuming that you already have an approved 360. So until visa becomes current, you have to keep yourself in status. But because you are a religious worker, if you are going to change to student visa, for example, it is advisable that you go to a Bible college, you go to a religious school, so as to be consistent in the path to be able to take advantage of the approved I-360. But you can't go from R1 to a secular school and then still expect to keep the approved I-360. So that will create a problem. So it is advisable that you go to a religious school. Next question. Good day, sir. Thank you for all you do. Thank you. God bless you richly. Amen. Please, sir, what is the amount needed for adjusted gross income from sponsorship for my daughter in Nigeria, age 19? Again, this is one of those questions that I cannot give you an answer. Adjusted gross income depends on your family size. It depends on your family size. The way affidavit of support is calculated depends on the family size. So if you are making, let's say you are making $60,000, and in your tax filing, how many people do you claim? You claim yourself. If you are married, you claim your spouse. Let's say you have 2 children, you claim those 2 children. Then you are petitioning for another child, that's already 5. So that's family size of 5. So you go and look under the poverty alleviation guideline. Poverty alleviation guideline. Can you please help me pull the poverty alleviation guideline? Let me give them the figure. So you check the poverty alleviation guideline to determine how much you are required to make. So now, under the current poverty alleviation guideline, for a family size of 2, you are required to make 125%, 125% of 21,150. That would be 26,500. You are required to make not less than 26,500, assuming that you are a family of two. Let's say you are single and you are filing for your child. That will be two of you. So you'll be required to make not less than 26,500. Now, assuming that you are married, you, your spouse, and this child you are petitioning for, that will take you to family size of 3. For family size of 3, you'll be required to make at least 33,500. Now, if you are a family size of 4, maybe you, your husband, and you claim one child in your tax return, now you are petitioning for another child, that's family size of 4. So for family size of 4, you are required to make 40,200. 40,200. Now, assuming you are a family size of 5, you will be required to make $47,062. $47,062. I will round it up as 47,100. For family size of 6, you'll be required to make 53,937. So I will round it up to 54,000. 54,000. Family size of 7, you'll be required to make 60,100. No, 61,100. 61,100. Family size of 8, you'll be required to make 68,000. Now, as I said before, it is the adjusted gross income that matters. So you may be making 6 figure, and by the time they deduct all these your expenses, business loss, and all of that, all your deductions here and there, they go back to the adjusted gross income. So with the adjusted gross income, they look at the number of number of dependents that you have on your tax return. That is what will determine the family size. You may actually not have more than 1 or 2 family members, but if in your tax return, maybe you claim that you take care of your mother or you take care of a child somewhere, all those things that you listed on your tax return, they will be counted towards your family size. And of course, the one that you are sponsoring to will be added to the number before they determine your family size. So you go back to look at your tax return, look at your adjusted gross income, and look at how many people you claim when you file your tax return, and then add the one that you are sponsoring. That will give you the total of family size, and then you know how much you need to make in order to be eligible. And if your income is short, then you need to get a joint sponsor.
2 more questions. That's it.
Okay.
And then we're done. So this is a follow-up to the EB4.
Okay. Isn't religious minister under EB4, or is it under other religious workers?
On the visa bulletin.
Let me say the way they categorize it. I know that they treat religious workers separately because they have large number of applications. EB4, religious worker, is also under EB4, but they treated them separately under certain religious workers because, as I explained before, they have large numbers, even though it is about 8 different categories that comes under EB4. But because religious workers have large numbers, that is why they treat them separately. So for the purpose of determining whether visa is current for religious worker, you have to look at certain religious workers, and you will see that currently it is you. You means unavailable. Visa is unavailable right now. That doesn't mean it may not change next month, but for now, it is unavailable. So that is why you have to keep checking every month once visa bulletin is released. Usually, it's released by the middle of the month.
Okay, this is the last question.
Okay, next question. God bless you and your team abundantly in Jesus' mighty name. Amen. What measures can someone who just lost the TPS take to be in status? This is probably from one of those TPS countries that were revoked. Well, if you have a current one that is not expired, you just need to quickly file a change of status. You have to change your status before the expiration of the TPS. That's the only thing you can do to keep yourself in status. So, but for those TPS countries, if you already have TPS, you will still use it till the expiration. They will just not renew it. So, if you have it already, just make sure you apply for a change of status before the expiration of the current one you have. Did you say that was the last question? Okay, I also see it's already 1:32 p.m. here. Okay, so on this note, we'll be ending today's edition of our podcast. We hope to continue again next week. Until then, as I usually say, avoid trouble, stay out of trouble. See you again next week. Shalom. And remember to invite your family, friends, colleagues. Let them be part of this information so that they too can they will not make avoidable mistake. Until next week, I remain yours sincerely, Dr. Olu Asekun.